financial crisis recovery.
Foreclosure, short sales, bankruptcy, credit card debt, job loss, depreciating home values, money management. Peace of mind when it comes to your finances seems completely out of reach under current conditions, but there is a way to achieve it. For the next 60 minutes, you're going to find out how to cover your assets. Cover your assets.
Involved in that transaction. I just described $1 million worth of net worth that nobody can touch. Nobody can touch.
Exactly. And, it's interesting. You'll hear banks, you'll hear people say, well, my bank told me that we had no choice. Everybody, all spouses always have to sign off. And I say, really? Does that mean single people can't buy houses? Is that what that means?
That's true.
It isn't some state law or statute. It's the bank's policy because they're trying to rope anything and everything they can. But that doesn't mean you need to do it. Remember, they're in competition to do the loans, so you can do a little shopping and you can find a bank who doesn't necessarily need to involve your spouse, their income, their assets, and everything else that you own. And that's something you need to be conscious of. Part of the problem that Tom's describing is people aren't even conscious of it. They just go in with their arms open. They say, hey, I have nothing to hide. Everything's on the table, and literally put their neck on the chopping block because nothing ever goes wrong until it does. And then it's too late. And the interesting thing, Tom, is when they come to see us, they don't even know what they've pledged with these loans. They don't even know. I say, do you have your loan documents? No. Do you know, were there collateralized assets? Were these cross-collateralized with other assets? Do you have 5 properties and they're all, they look at me perplexed and they own 15 properties. They don't even know what the heck I'm talking about.
The term cross-collateralization and cross-defaulting, they a lot of crickets when that happened when you talk to them about that. The idea that you're pledging assets of multiple assets to secure one obligation, or that if you default on any multiple assets or any multiple loans, it's a default in all of the loans. They don't know about that stuff a lot of times.
So with that, when we talk about the exempt assets, there's something to be said about managing equity within exempt assets, isn't there?
There really is. So, you can, just because you have this equity doesn't mean you can't access it. If you're healthy and you go to a bank and you ask for a home equity line of credit.
Healthy meaning you've got good credit, you're able to make. So in other words, an example might be, okay, look, Tom, I got $100,000 worth of equity in my primary homestead, and I've got this investment property that's paid for free and clear with $300,000 worth of equity. That could kind of be a problem if things went bad for you, couldn't it?
Really could. Why don't we take the loan and put it on the investment property where we can actually deduct the interest too, and as a business expense, and then take that cash and just pay down your homestead. And then you can go to the bank and you can say, look, I'm healthy, I've got great credit, I'm not late on anything. Would you give me a home equity line of credit? Well, they're in the business of loaning to people that are financially healthy. So they say, sure, here's a home equity line of credit. If things go bad, you can always access your home equity line of credit, provided they haven't pushed it. That's the one creditor you want to make sure that you're not doing anything where you're late on payments or anything, and you can access that and nobody can touch it.
So in other words, you could go to that investment property. You could take out, let's say it's owned free and clear. You could take out a loan, and the security interest would be collateralized against the investment property, which means a term we're going to be getting into in a moment here. It would be encumbered by a loan. And we would then take those dollars, that value of $300,000, and we would take a portion of it, say at least if you got $100,000 in equity, $260,000, and we would use of that loan $260,000 to pay down our primary homestead, creating $360,000 worth of an equity position in our primary homestead. And in that case, it would be protected should anything ever go wrong.
Yeah, and there's another thing that got protected in that transaction. You've actually protected your investment property from creditors, because a creditor is now going to look at that and say, geez, do I really want to pursue an asset that has $100,000 encumbrance against it when it's only worth $125,000? So I'm going to go through all this effort just to get $25,000. Yeah,
exactly.
Maybe not. So you've actually dissuaded creditors from accessing the assets from which you can come back from.
Well, this is fabulous, and it's a great jumping off point. We're going to come back, and when we do, we're going to talk about a little more advanced techniques. So once a person has taken advantage of their exemptions, those things that we've just described, and there's more, and it's more detailed, and we can't cover it all on this show, but once you've done that, then you need to move into a little bit more advanced techniques for assets that exceed the allowable exemptions, and then you get into a little bit more finesse, and that's where Tom is an absolute expert. So we're going to come back and we're going to talk about that. If you're curious about how to protect your assets, please give us a call. The number here in the studio is 651-646-8255. Also want to encourage you to go to our website, which is CYA21.com. That is Cover Your Assets, CYA21.com, and download the Financial Crisis Bible. Give you a tremendous amount of information, help you build that vocabulary, and help you to have a meaningful dialogue with somebody like Tom. So when you sit down with him and he's willing to give a free consultation, something that he does and I don't, he can really give you some great information because you've already got a basis of understanding. So we're going to go ahead and take our break. We'll come back, and when we do, we're going to talk about a little bit more advanced techniques once you've gotten past the management of your exempt assets. We'll be right back. Welcome back. We are here with attorney Tom Fofinski, estate planning and asset protection in Minnesota, possibly the best estate planning asset protection attorney in our state. Talking about how to preserve and protect your assets. We left the last break, and I want to encourage you again, if you have questions, concerns, want to build your financial vocabulary, go to the download, CYA21.com, and once there, CYA21.com, once there, download the Financial Crisis Bible. We left the last segment talking about, the exempt assets that can be protected, my goodness gracious, all the way to bankruptcy. We always move out from the worst case scenario and then develop strategies and different contingency plan A, B, and C as we go. We're now going to be moving into a little bit more advanced techniques here. Once you've covered all of your exempt assets and you've got those stored and those are okay, now your assets are exceeding those exemptable assets, and now we need to do other things a little bit more advanced. And Tom and I were talking about how to encumber assets that are not going to be exempt in bankruptcy, but certainly we can slow things down, protect them, and do a lot of things. So Tom, talk a little bit about what does that encumbrance actually mean and how might one actually do that with assets?
Yeah, to start out, you mentioned earlier about the spectrum. And the spectrum is really important when you start talking about some of the intermediate to advanced techniques of protecting assets and estate planning. And so the spectrum is, and let's just say, white is lily white and pure, and the transactions are fine, and it's that type of beginning planning before there was ever any problems. And the black are transfers that are, they're going to be reversed. They're going to be turned around. They are a violation of the Uniform Fraudulent Transfer Act, the acronym of which is UFTA, which I think is wholly appropriate for an acronym for that, because not only does it reverse liability, it can potentially impose liability upon transferees as well.
Which is to say, transferring assets in an effort to hinder or delay creditors from being able to collect what is theirs, what is rightfully theirs. And so we're talking about transfers that are improper, and even so far as to say what we would consider a fraudulent conveyance of assets at the end of the day. So once we get into that area where, holy crap, you got a judgment on the table, you start trying to move things around real quick, you're going to wind up with those types of problems. So you got to do that long before, and that's that area.
Exactly. And you start out with a solvency analysis. So you say, okay, well, I've got debt of $500,000 and I've got assets of $1 million. Well, that means you can very safely now transfer that $500,000 into other protected environments, take them away from creditor penetration, unless they're secured. Creditors won't be able to access them. You got to tell the truth about it when they send you a financial statement. If you've transferred it to your spouse for some reason or another, you actually have to tell them. You can't say, no, this is our joint asset anymore. No, it's not your joint asset anymore. But it's a safe transaction now because you've met the solvency analysis.
And of course, why did you do that? What was the premise under which you did that?
Why expose the asset?
Well, how about this? Estate planning.
Oh, the premise, yeah. So the other piece of asset protection planning is if you go to a judge and you say, well, judge, this is what I did. I went to Fafinsky and he said there's a solvency analysis and anything over $500,000 I can transfer it. And if I do it to this particular environment, then creditors can never get to it. Well, the judge is going to scratch his head and go, your only reason to do that was asset protection? I don't think so. You really need to have an ostensible purpose other than asset protection if you really want to make sure that you can protect that transaction under UFTA.
Which is the whole point that I made earlier in the show today, which is that you're not protecting assets, you're doing estate planning, because protecting assets already presupposes you're trying to hinder your creditors, which is already problematic, right?
Absolutely.
So we need estate planning as a justification as to why we're doing what we're doing, generational tax and moving assets to a continuation plan to the next generation and things like that, right?
Absolutely. It could be retirement planning too. Well, I did this because I wanted to maximize my retirement. So when you're managing that exempt asset of your 401k, 401ks are gorgeous. I love 401ks because it's state law. You know, if you've got a profound 401k and you're in your 50s, you're going to be fine. You'll never have to file bankruptcy because that asset is golden. It's protected. State law, federal law. IRAs are a little bit different. They're only exempt up to about $66,000 in state court. You have to actually file bankruptcy to get the $1 million protection. Lots of my clients, they don't want to file bankruptcy, and especially when you catch them earlier on in the planning, when they're planning on purpose, they absolutely aren't planning to eventually file bankruptcy.
But see, of course, the backdrop is bankruptcy, and every creditor knows that all you got to do is pull the trigger on that. And if your retirement account is your income at that point, you basically are going to meet the means test because you're not going to have any income per se. And if they want to push the issue, bankruptcy is the backdrop, and then you do have the $1 million.
Yeah, so
right?
it's the worst case scenario.
Yeah. So I mean, it's interesting when you look at negotiating with creditors. You say, okay, you can pay all the money and shut up. That preserves your credit. You can negotiate for a percentage, or you can file bankruptcy and discharge the debt. And as Tom said, almost nobody wants to file bankruptcy. Having said that, if you're in a position to be able to do it, it's hard for the bank to fight with you, a kamikaze who just says, screw it, I'll just file bankruptcy, because it becomes the best leverage you have to make them negotiate with you, right?
It really is. I mean, you really are. So I'm not going. I have nothing to protect, and therefore I'm going to file. I don't have a job where I've got garnishable wages or so you can take the worst case scenario bank.
Yep.
Or you can take these payments over time or structured however. Yeah, you can get some. You can get, especially now. It's kind of funny. The world has kind of gone upside down in this regard. It used to be that if you were a healthy bank and somebody made that proposal, that you would be more likely to say, okay. Now, if you're an unhealthy bank and somebody makes that proposal, and they say, okay, I'm going to pay 25 cents on the dollar, that unhealthy bank is looking to free up the reserve funds. The unhealthy bank is now more likely to say yes to that transaction than years past.
Absolutely.
10 years ago, it would have been, it was just.
They had a strong posture. They could wait. They'll take payments over 20 and 30 years because, hey, at the end of the day, that's the business they're in. But when they've got that pressure to free up those dollars, and as Tom described earlier, it's not just the